right, this is case number 21-173-478. This is Beaumont Hill versus Barbara Brown. Matters before the court for a scheduling or a status conference. Your appearance for Beaumont Hill, please.
Yes, Your Honor. This is Hal Burke, P69068, attorney for Beaumont Health in this case.
All right, thank you, Mr. Burke. Good morning to you. I'm looking now for Barbara Brown. Ms. Brown, if you're on the Zoom, please say something at this time.
Yes, I'm present.
All right, good morning to you, Ms. Brown. I see that this matter has been joined by the following of the defendant's answer. Did you, in fact, receive a copy of the answer, Mr. Burke?
I did,
yes,
Your
I
Honor.
did.
I'm sorry.
Talking to Mr. Burke now. Ms. Burke, did you receive a copy, sir?
I did, Your Honor, and we have resolved this case with your permission, and I think Ms. Brown agrees with this. He has already begun a payment plan, and we are emailing her. I'd like to get her email, a consent judgment for her to review and sign, and then get to you, Your Honor.
Right, Ms. Brown, is that the size of it that you've come to an agreement regarding the amount of an order that would result in a payment plan? Is that correct?
That is correct, but I just have one question for the plaintiff's attorney. I have been making payments on this account from July 2020 through September 2021, but I'm just wondering, is it falling under another account, a guarantor account? Because I have that account number. Are they linked?
Your Honor, I don't know which account she's discussing, but with your permission, if we could adjourn this for 2 weeks, she and I will call her after this hearing and get her email address for the proposed consent, and then answer her question on any additional account she may be paying. She is paying on this account, but not since that date she just mentioned. She may have a separate one.
All right, so I will go ahead and send it over for a couple of weeks, just so that you can work on the logistics. My preference is that the parties resolve all of that today. And typically you can do that, particularly when you put on the record what the nature of the settlement is, and if that is in fact the agreement, then the parties can stipulate to a signed consent order and email that to me today, and I'll sign. Perhaps you can do it that way. Have you had a moment to talk in the breakout room, perhaps to narrow those things down so you can order over to me today?
We have not spoken, Your Honor.
Yeah,
she began her payment plan in January on this case, though, not July.
All right, so let's do this for a moment. Ms. Brown, where are you? Say something again, ma'am.
I'm sorry. Could you repeat yourself, Your Honor?
I've got you now. I was looking for where you were because you're there without a name. So I'm going to send you a notification to go into a breakout room, and you'll have a chance to speak with the attorney on the other side for a moment, and let's see if we can bring the differences together to try and get this taken care of. So I'm sending you breakout room number 1 with Mr. Burke. Then you'll be able to come back into the Zoom. All right, you got a notification. Just click into the notification to take you to the breakout.
Okay, and she can do that by phone? Will she be in there as well?
Mr. Burke, you have the notification, sir. All right, this is case number 21-153-543. This is integrated MRI Center versus City of Detroit. Matter is before the court on the filing of a motion for a summary disposition. Your appearance for the plaintiff in this matter, please.
Morning, Honor. Daniel Groves on behalf of the plaintiff, P number 74026.
All right, thank you, counsel. Good morning to you. For the defendant in this matter, your appearance, please.
Good morning, Your Honor. Charlotte Bennett here on behalf of City of Detroit, P number 85699.
All right, thank you. Thank you, Madam Counsel. It looks like the motion sounds like one for summary disposition in lieu of answer, a request for declaratory relief. I don't see a written answer to the same for the plaintiff. Have you had opportunity to do so?
Yes, we submitted both the court and the defense, and then actually defendant submitted a reply to our response.
That's correct, Your Honor.
Well, to put it somewhat mildly, it seems that I'm missing something. All right, so I take it. Just 1 second. Yeah, I'm missing a couple of pieces. Let me ask you, Madam Counsel, give me the general sense of your motion in this regard.
I'm sorry, Your Honor, can you repeat that? I didn't quite get that.
Give me a little information on the general sense of your motion.
Oh, absolutely, Your Honor. So the partial motion for summary disposition is just based on the fact that plaintiff makes a claim for breach of contract in this action without either attaching the written instrument or noting why they could not attach it in violation of MCR 2.113F. And so our plaintiff did respond to those allegations, and I believe, of course, I'll let Mr. Gross talk about that, but they're requesting that they have leave to amend instead of that being disposed of here today. And our only issue with that, Your Honor, is that because this is a City of Detroit matter, there is no contract. This is a statutory claim, so we're just asking that the breach of contract claim be dismissed. We're certainly not asking at this point that the statutory claims be dismissed on this matter. And then the declaratory relief portion of the motion has to do with the amount in controversy in this action. Plaintiff alleges in their complaint $5,200, which represents a single date of service. But then their attached invoice has 3 additional dates of service that were actually dealt with in another lawsuit filed prior to this one. So we're just asking for declaratory relief that states that this action only deals with the single date of service relating to the $5,200 claim and does not include those other prior dates of service which were dealt with in another lawsuit and which now under this current lawsuit would violate the 1-year back rule.
Right, and you would also indicate that those items, those 2 items that you point out, they'd be the subject of res judicata. They could formally resolve. They've already been dealt with, correct?
Oh, that's correct. For the other dates of service, yes, Your Honor.
Got you. Mr. Gross, with regard to the breach of contract aspect of your claim in this matter, how is that claim going to stand up under the argument that has been made where there's no existing contract?
Your Honor, it's a moot point. It's two sentences, 2 lines. It's an assumed. The law is well familiar with an assumed contract. But Sister Counsel's right, it falls under statutory. The bulk of the complaint is statutory. So whether it's in there or it's not in there, we put it in there, but it's an assumed contract. That's what it is. But if the court doesn't like the 2 sentences that say that, the claim's not going anywhere. It doesn't disappear because of that. All the amounts are still there. So I leave it to the court's discretion. It was put in there because of the fact in the past, if one wants to argue that there is no cause, well, at a minimum, there's an assumed contract, and we can't get a hold of course, any negotiations and or contract from the city because it's a passenger on a bus. But it's moot, so I leave it to the discretion of the court.
Well, that was a law school argument on these points. I appreciate the minor points that you addressed, but I think that the first word out of your mouth was that it's moot. And I agree with you essentially there. So I'll grant the partial motion for summary disposition as related. Specific claim sounding in a breach of contract in this regard. It does not affect the underlying claims that have been asserted, and to the extent that there are arguments to be made of their similarity to an implied contract, and obviously that survives within the context of the claim that the plaintiff seeks to bring in this regard. As it relates to the narrowing of the complaint to the one claim for benefits in excess of $5,000, and the exclusion of others that seem to, at least on the arguments of defense counsel, those claims seem to have been resolved previously. Counsel, anything on that at this time?
Yes, sir. I think Your Honor just said it correctly. They seem to be, but the court cannot move forward under the rules of evidence or the court rules of seem to be. Defendant has failed to produce any evidence, and the burden is on the defendant. We've submitted the bills. The burden is on the defendant. If defendant wants to say they've been taken care of in another case, in the underlying case, well, then please show through an exhibit or evidence that that is the case. As it stands right now, Your Honor, under MCL 500.3112, my provider has a right, independent right to of a cause of action. We're pursuing it. We filed it. That's all correct. Then under MCL 500.3145, subsection paragraph 3.
Let me stop, Mr. Groves. Mr. Groves, let me stop you for a moment. The predicate for the filing of claims as it relates to claims of injuries arising out of automobile accidents and the right to bring the action under the updates in the statute and so on and so forth. None of that is part of the argument today. I think that what that part of the motion seeks to do is to see if the parties are on the same page in that regard. Obviously, when the court used the language seems, obviously that's not a polished legal articulation. I think that what is being said forth here is that if in fact the other claims have in fact been resolved, and that is something easy, that is quite easy for the parties to be able to arrive at. And it seems to me that what I've heard from Mr. Groves is that he has not arrived at that. It seems to me that the documentation that it would take to narrow that issue is quite an easy one. I thought perhaps today that with the notification that the plaintiff was seeking to narrow the issue by pointing out that those claims have been previously resolved, that the parties would have taken a look at this, and the plaintiff would take a look at this on that notification and resolve that as to whether or not that was true. That does not seem to have been done at this time. So certainly that part of the motion for declaratory relief of the court will take that motion under advisement, will allow the parties to litigate the matter, and the plaintiff may request at the appropriate time, strike that defendant may request at the appropriate time, court rule upon the issue of whether or not the previous matters have in fact been resolved. That seems to be a matter that's open to discovery between the parties and or the submission of an appropriate document showing that those matters have already been resolved. So I'll take that issue on the file. All right. So what else needs to be cleaned up regarding this matter? How much discovery is done? What do you need? What involvement do you need to report at this time?
Your Honor, plaintiff respectfully requests, first, plaintiff concurs with Your Honor's opining and ruling. I think that is correct. I appreciate that. But plaintiff requests to amend because there was an administrative error, and I agree with sister counsel. When the complaint was originally filed, there was an administrative error where they looked at only one date and put that amount. That's not correct. But the exhibit attached to the complaint showed the full amount, which is $22,300. That is the amount seeking. If we can all agree on that today and have it put in the order, that would be great. But if the court wishes me to amend it to say the administrative error of only one date of service is not correct, we're seeking all the dates of service, I would like to do that. I would only also humbly suggest if the court wants to wait while it's under advisement for sister counsel and myself to resolve what has been already paid for and not through the underlying case, then I can wait for that and amend thereafter, but I just need the proof of those documents and resolution, please.
Well, Your Honor, if I may respond, I would like to do the latter of the suggestions that Mr. Groves just put forth, and have it also be held open for, us to go ahead and submit documentation showing what has been claimed, because or what's been paid. I certainly don't want to amend to have it include an amount that we're going to, end up saying some of that's already been resolved.
Well, the amendment, if granted, would simply be a notice pleading once again. It would not be a factual determination, obviously, as the parties know. I will take both issues under advisement. In the first instance, in relationship to dealing with whether there are some residue kind of issues, the court took that under advisement in hopes that as the parties litigate the matter, they'll be able to narrow issues. Counsel for the plaintiff has put the court on notice that we would like to have opportunity to amend its pleadings based upon further information. And that motion is taken under advisement. The rule, of course, is that amendments are to be freely granted where justice so requires. And obviously, if there is some indication that the plaintiff, through some administrative error, did not include something, they wish the opportunity to put the plaintiff on notice of the same, right, the defendant on notice of the same, then the probability would be that the court would grant such opportunity to amend the complaint. I'll hold that in abeyance now. Both motions are taken under advisement, and my gut on this is that as you look at the logistics that are stubborn, that is what has already occurred, that you're likely to find the way forward, and then wherever the court needs to engage, I will engage in it. All right, so let's set a next action date in this matter. I'm going to put it about 45 days out, and we'll come back at that time and take a look at exactly where the file is. So next date in this matter is going to be
May 19th.
5/19/22, and that's going to be at 9:30 a.m. 5/19/22 at 9:30 a.m. We will get a notice regarding this matter, regarding that date. That date is being treated as a pretrial conference date.
Your Honor, will sister counsel do an order, or does the court take care of that, please?
If somebody wants to do one, get it to me right away, or I'll do it. I mean, it's, yeah, let me do the order. That way I know to get done today. All right. All right.
Thank you, sir.
All right.
Thank you, Your Honor.
Thank you.
Sure. All right. Good day.
Thank you.
You too.
All right. The court now calls case number 21-164-857. This is JHP Finance LLC, Finance One LLC versus Michelle Harrison. The matter is before set for a review on today's date. Counsel, excuse me, just one moment. I'm coming now to the suffix 478. I'll be right back with you on the one that I just called. 478, Beaumont versus Brown. Mr. Burke, I see that you're there, sir. Welcome back. Ms. Brown, are you there, ma'am?
Yes, I'm here.
All right, thank you. Mr. Burke, update me if there are any updates at this time, sir.
Yes, Your Honor. Ms. Brown and I have resolved this case. She is paying, and actually began this in January, paying $150 a month. She's current on her plan. I received her email address, and like you had requested, I am going to get her a proposed consent judgment for her to review and sign today. Ask her to email it back to me, and then get it to you for your approval, Your Honor. I also mentioned to her, one of her questions was she has a different case, I believe, out there, and I will assist her on that one as well. And I think she and I are in a total agreement, Your Honor.
Yes, we are.
All right, very well. So I'm going to give you, counsel, the court's email address where you can send it once you're ready. That's Latifah, LATIFAH dot last name Latifah at 3636th district court.org.
Would you mind saying that one more time?
Yes, the first name again is Latifah, Latifah dot Hunter is the last name.
Hunter,
Yes, at 3636GH districtcourt.org.
got it. Thank you.
All right, we'll get that out to you, Ms. Brown. We'll make sure that you get a copy as well, ma'am, all right?
Okay, thank you so much.
All right, good day to you, ma'am. Good day, council. Thank
You
you.
too.
Your Honor, may
Thank
I
you.
ask Ms. Brown one more thing before she hangs up?
Ms. Brown, just one moment. Ms. Brown. All right, go ahead, Mr.
Yes.
Ms. Brown, do you have the ability to receive an email, sign it and scan it and email it back to me all within one day?
I believe I can. Can I do it through my phone?
I don't think so. You have to print it, read it, of course, sign it and scan it and email it back to me. I don't think you can do that through a phone.
Well, you can actually do it on the phone, but let's do it this way. Ma'am, if he puts in that order, the language that you agreed to, do you have any problem with putting your name by consent?
Okay. I'll try it the other way. I'll print it and sign it and scan it.
All
If you don't mind.
That's right. The other thing that the court is going to do is once I know what the thing is, and then if it doesn't comport with that language, then I wouldn't sign it anyway. But you go ahead, ma'am. You guys do it that way. Let's see if you get it into me as soon as possible. I wish you well.
Okay.
Go ahead and follow your process, and I'll wait for you. Thank you. Good day to the two.
Thank you,
Okay,
Your
thank
Honor.
Thank you, Your Honor.
All right, thank you. And I am on the record now regarding JHPD Financial One, which is Michelle Harrison. The suffix on that is 4857. Your appearance for the plaintiff in this matter.
Yes, good morning. This is Natasha Dixon on behalf of the plaintiff, JHBD Finance One LLC. My PIN number is 82333.
All right, thank you, Councilor. Good morning to you. I'm looking now for Michelle Harrison, please. Say your name with you here, ma'am.
Good morning, Michelle Harrison.
All right, thank you, Ms. Harrison, and good morning to you as well. I did set a scheduling order previously on this, and then when the case was last here, it was adjourned. I adjourned it and then set it over for review. Madam Counsel, remind me, there was something, some logistics that were being worked out. What's the status of things?
Yes, Your Honor, that is correct. I did discuss last time with Ms. Harrison a settlement offer. I am actually finalizing the settlement terms with my client because she wanted something specific as far as the credit report. So there's something specific involved. So I am finalizing the terms with my client as soon as they, kind of finalize that and give me the okay. Basically, I will send over settlement documentation to Ms. Harrison.
Well, Ms. Harrison, as you're in the process of getting this all settled up, and there's some further review that has to be done with the council's client in order to reach that conclusion. That seems like to be the size of this case. Is that what your thought is in regard to this as well, Ms. Harrison?
Yes, Your Honor.
All right, so I'm going to adjourn it for 2 weeks, bring it back in the short term with the hopes that on both sides will in fact have things all worked out. And on that day, I'll be able to get updated as to the order and what will be done next. So that date's going to be 2 weeks from now.
20 April.
4/20/22. That's at 9:30 a.m. 4/20/22 at 9:30 a.m. And of course, if you get it all worked out before that time, then a signed order can be submitted to me. And if a signed order is submitted to me, then a signed proposal order submitted to me, that will cancel the court date. So if you get everything worked out, the attorney will submit a document to the court, and that will cancel the court date. If not, then you'll come in on the court date and we will finish everything up at that. All right, you'll get the date in the mail. That's April the 20th, 2022 at 9:30 a.m. I wish both sides well.
All right, thank you, Your Honor.
Thank you, Your Honor.
The court now calls case number 21-16601. Strike that 0. All right, 21-166-061. This is Cash LLC versus John Coleman. John E. Cozy. The matter is before the court, set on for a, looks like a general hearing. Your appearance for the plaintiff regarding this matter.
Good morning, Your Honor. Keith Sparks here on behalf of the plaintiff, Cash LLC, P77485.
All right, thank you, and good morning to you, counsel. For the defendant in this matter, John Cozy, your appearance at this time, counsel.
Sorry, you're still on mute, sir.
John Finn, appearing on behalf of the defendant, John Cozy, and my P number is P33678.
All right, thank you, Mr. Finn, and good morning to you as well, sir. I do see that the matter is properly joined. I have the answer. He's been able to talk about this a little bit, or you, what's going on here? I know you may need some discovery, but let's see where you are with this. Somebody talk to me.
At this point, I don't believe my client is willing to come up with anything at any offer at this point. We don't see where the defendant states that somewhere that my client has copies of everything, and he doesn't. And we don't think that they have anything. And we need some discovery, Your Honor.
Got you. Sounds good. All right, Mr. Sparks, anything before I set a schedule on this matter, sir?
No, not at all. That's absolutely fine. We'll if we get a discovery request, or if you want to just shoot me an email or give me a call, I can email over the docs that we have, and then hopefully go from there.
Okay.
All right. What the court is going to do, I will open formal discovery, and I'll allow a period of 60 days for you to go forward in that regard. I'm going to set a return date, and the discovery will be open through that date. That return date, about 60 days out, is going to be May
26th.
May 26, 2022, and that's going to be at 9:45 a.m. That date of May 26, 2022 at 9:45 a.m. You'll have through that date for the exercise of discovery. Also, the court will allow for the hearing of motions on the 26th of May. Those motions can be dispositive or non-dispositive, and I will hear them on that date if you notice up your motion for hearing on that date. The only requirement is that you allow the opposing party at least 10 days to respond to the motion. I realize that by doing this, I'm shortening the time that would normally be allowed with motions for summary disposition, et cetera. They're being shortened by court order. That means that if you wish to file a motion and you want it to be heard on the next action date, which is May 26th, you may file such a motion. But you do have to allow the other side at least 10 days opportunity to respond to the motion prior to the hearing. And if that's done, the court will hear the motion on that date. This does not cut off opportunities that may exist in the future for filing motions. It just gives an efficient way to bring an issue before the court if you wish to do so without having to set another court date. May the 26th gives you that opportunity. It is set for a pretrial. It can also be a motion hearing date if you set it properly. You'll get a scheduling order from me with that, with the information that we've gone over today. It will be mailed out to you, giving you the court date as well as the language regarding the opportunity to file motions dispositive and or non-dispositive. All right. Any questions at this time, gentlemen?
Nothing further, Your Honor.
Nothing.
But I wish you well. We'll see you in the near future.
Very
Thank
good.
you both.
Thank you.
The court is calling case number 01-119-358. This is Gold Key Lease Incorporated versus Lawrence Dandridge. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that the judgment in this matter was renewed, strike that initially entered on this, the 6th of September 2001. The amount was $15,686.32. That same judgment for the same amount was renewed on May 4th, 2021. And the plaintiff has sought collection efforts by filing an application for garnishment against, it looks like Faurecia Automotive Seating. All right, your appearance for Gold Key at this time.
Good morning, Judge.
Just one moment, sir. Gold Key, Lease Incorporated. If you're on this Zoom, let me hear from you at this time. All right, I'm looking for Mr. Vandridge at this time. Good morning to you, sir.
Good morning.
All right. I see that you filed the objection to the writ of garnishment. You indicated that your reasons for objecting is that the judgment has been paid, that the writ is not properly issued or otherwise invalid, because you did not get it. I show that there is still a judgment that is outstanding on this case, sir. Do you have a document showing a satisfaction of judgment or anything?
I don't have a satisfaction judgment, but they received the property back and I was making payments. But what my thing is it was only $15,000 and then they took it up to $70,000 on me.
I don't see anything regarding $70,000, but I'm sure that some interest accrued over time. But the judgment that was entered, the problem, of course, is that that judgment was entered in 2001, and whatever portion has not been paid, you likely have had interest accruing on that $15,000 judgment for like 20 years. I guess that could get to be pretty expensive.
Yeah, but I have paid it off. They got the car back and everything, but I don't understand why they kept charging me.
Well, if they got the car back, they likely auctioned the vehicle and then came up with a deficiency or that what was left to be paid. The challenge here is that we're way past those kind of things. The challenge is that a judgment was entered in 2001, and then that judgment was renewed in 2021. So you've got a situation where this has been, of course, going on for a long time, but you still have a judgment against you.
Yes,
So,
but I never received any documentation or notification or anything like that.
Well, it is looks like a 20-year-old case to me, but you still have a judgment against you. I see back in, I'm just looking through the register of action now, and I do see back in 2006, where there was a judgment made of $24,000. So obviously that's because of accrued interest on the matter. So when you say you paid it off, what payments have you made? What payment history do you have on this, sir?
Well, I haven't received any documents as far as paying that off, and I didn't receive anything as far as them telling me that I have an outstanding balance or anything. It just ran up and I didn't know about it. They did not receive. I just received documents saying I owe $70,000 on this account.
All right.
And I never bought anything worth $70,000.
Yeah, well, I've already gone over those things for you. I don't think that you have to be so concerned about the 70,000. You have to be concerned about the fact that there is in fact a judgment against you. That's your problem. Is that there's a judgment. Owe some money, and because you owe some money, the plaintiff has the right to go after you to collect. Now, Faurecia, is that the place where you work, sir?
Yes, and that garnishment is hurting my family.
No, it couldn't possibly be hurting your family that your money is being taken. I'm being facetious. For sure it's hurting your family if your money is being taken, all right? So that's why we're here to kind of address some of that. How much money is taken from you? What do you get paid, every other week or what?
Weekly.
All right, you get paid weekly?
And they done cut my hours and everything.
I don't need to hear all of that. I need to get to the point now. How much do they take out of your check on a weekly basis? Approximately, or the range?
Half almost.
You know.
Oh, I'm not, the amount is at least 200 if I was working 40 hours, but they taking half all the time.
Gotcha. So when they take $200, they take that every week?
Every week.
All right, so about $800 a month is what's being taken from, correct?
Pardon me?
About $800 a month is what's being taken from, correct?
Yeah,
All right, so I don't see a basis for the objection to the writ of garnishment. There are only narrow reasons why we could do that. So I will find that the objections are invalid. Any funds taken, I'll release those to the plaintiff. I'm gonna go ahead and stop the garnishment, sir. And I'm gonna put you on a partial payment situation so that you can find some ways of dealing with this. The plaintiff is not here, so I'm not able to get to them to talk about what it is that they believe might be owed under this situation. So I'm going to go ahead right now and I'll set your payments at $100 a month. And,
thank you, sir.
It may go up. It may go up in the future. It depends on what the plaintiff files with court. But right now, I'm going to set it at $100 a month. This has been a situation that's been going on for 20 years. So we'll see where it goes from there. So any money you already paid out, that's going to be released to the plaintiff. Starting on the 22nd of April, you make your first payment. April 22nd, you make your first payment of $100. And you
Thank you, sir.
You continue that on a monthly basis until further order of the court. You understand, sir?
I understand. Thank you.
All right, you'll get paperwork from me in the mail, sir. I wish you well. Good day to you, Mr. Daniels.
Thank you so much.
Thank you. That's just.
Okay.
All right, the court now calls case number 18-162-136. This is Midland Funding LLC versus Melvin Stewart. The matter is before the court on the filing of objections to a writ of garnishment. This garnishment regards the Michigan Department of Treasury. The record should reflect that a judgment was entered in this case. Looks like on the, just one moment here. On the 15th of November 2018, that judgment was entered for $1,208.53. The plaintiff seeks to collect on that judgment at this time. For the plaintiff, Midland Funding, your appearance at this time. I have someone from Midland Funding. All right, do I have on this Zoom Melvin Stewart? Melvin Stewart, if you're here, say something, sir. Melvin Stewart, a person purportedly living on Schaefer Highway in the city of Detroit. Melvin Stewart. It appears now that the defendant has not appeared regarding this objection to a writ of garnishment. Accordingly, the court will deny the objections at this time and allow any funds that are withheld to be released to the plaintiff. So ordered at this time. All right, this is case number 20-148691. This is Auto Advance of America Incorporated versus Brittany Taylor, Kyla Brittany Taylor. The matter is before the court. Looks like on the filing of an objection to a writ of garnishment regarding the State of Michigan Department of Treasury. Your appearance for Auto Advance of America, please.
Good morning, Your Honor. May it please the court, Keith Nathanson, P41633, on behalf of Auto Advance.
Thank you, Mr. Nathanson, and good morning to you, sir. All right, I'm looking for Greenfield Road, apartment 4 in the city of Detroit. If you're on the Zoom, please say something. All right, counsel, any information you can bring to the court's attention in this regard, sir?
Well, Your Honor, it looks like Ms. Taylor objected to the garnishment, indicating the judgment has been paid. I have searched my records and I have represented Auto Advance in this matter since its inception of the instant matter, and the judgment, in fact, has not been paid. Ms. Taylor also indicated that there's bankruptcy proceedings. I did perform a search on Pacer, and she did file bankruptcy back in 2016. However, this transaction with my client happened almost 3 years after the bankruptcy in 2019. So the 2016 bankruptcy discharge would obviously have no effect on a 2019 post-petition transaction. So because of those two things, we just ask that the court deny the objections as invalid.
Thank you, counsel. All right, the court will deny the objections to the writ of garnishment for the reasons set forth on this record. I don't have any paper to do this. Just a blank check.
No problem. No, there's no problem.
All right, I'll sign an order consistent with the denial of the objections to the writ of garnishment regarding this matter. Looks like there is also case number 21-58691, D&F Associates LLC versus Gladys Perles, P-E-R-A-L-E-S. That looks like objections to a writ of garnishment as well. Mr. Nathanson, do you represent, well, let's see, who's the counsel on that? Yeah, D&F. Do I have Pearls, Gladys Pearls? Objection. So,
Okay.
all right, the court is calling case number 21-58656. This is Midland Credit Management Incorporated versus Sherfield or Beverly Sherfield.
Beverly Sheffield's here.
Morning, Your Honor. Brian Truba appearing on behalf of the plaintiff Midland Credit Management. My P number is 61752.
All right, thank you, counsel, and good morning to you. Someone who spoke out of turn and said that they were Beverly Sherfield. Good morning to you, ma'am.
Good morning. I apologize.
No problem. You did file objections to a writ of garnishment regarding the entry of a judgment that is dated the 13th of April 2021. That judgment was for $1,181.37. This garnishment is directed to the third party withholding unit for the Department of Treasury. I looked at your objection to the writ of garnishment. It seems that you pointed out I have never signed a contract with Midland Credit Management Incorporated. Don't know who they are. And that seems to be the basis of your objection in this regard. Is that correct, ma'am?
Yes.
So the challenge here is that type of that type of objection is something that you have to raise because raising the underlying case because you're attacking the entry of the judgment. We're already past that point. If you, for some reason, believe that the judgment should not have been entered, then you would have to file the appropriate paperwork to try and challenge that. So what you're challenging, what this case is about post-judgment. There's already a judgment in it, and the plaintiff seeks to collect from that judgment. That's where we are. And the objection that you raised seems to go back and say, well, there shouldn't be a judgment. You have to do that differently. You can't do that in a post-judgment proceeding. So this, it sounds like just by way of information, then I'm coming to counsel. It sounds like this was something that related to Comedy Bank, Community Bank.
Right, Your Honor, it's Comenity, I'm sorry to interrupt, Your Honor. Comenity Bank issues a lot of merchant credit cards. The store name on the card would have been Venus. I believe it's a woman's clothing line.
Say it again, the name of the store would have been
Venus.
Venus?
That's correct, Your Honor.
All right, but it's not you, there's something wrong with the sound a little bit distorted, so Mr. Drew, that's why I couldn't really hear what you were saying. All right, so that's a bit of information regarding the background on this, Ms. Sherfield. It has something to do with a store called Venus, etc. But what we're dealing with today is past all of that procedurally, and it has to do with post-judgment. The only, the kind of objections that challenge post-judgment stuff is like, I filed bankruptcy, or I've already paid it off, or things along those lines. Do you have any of those kind of objections that you wish to bring to my attention?
No, but the time that they went into the, they filed for the garnish, I had moved, and for like a good month, I didn't get any mail. It's like they were like taking my mail and just throwing it away. I never got my tags or anything. It's like for a good month, I had to even contact the post office that I didn't get mail. So by the time I got it, that's when I sent it in to object.
All right. So anything that might relate to the underlying case, your objections are on time regarding the garnishment. But if you're saying that there is something that you didn't get in the underlying case, there is a proof of service regarding items being attached at the property on Orleans Street. And if you believe that you did not get properly served or whatever, you do have the right to file a motion in that regard. You can't raise that in this hearing, but you can certainly file a motion and ask that that issue be heard. All right. So how much money are you expecting from the state income tax return?
I think they already garnished it.
You know, I didn't ask you that question, right?
I apologize. 1,400.
Oh, okay. Well, yeah, that would pay this judgment off, I think. All right. So, counsel, anything, sir?
Nothing, Your Honor. You summarized our position. Just for the record, Your Honor, I'm showing a balance of $1,200. So if there's any overpayment, Your Honor, we'd of course return that to the defendant.
Yeah. So at this point, Ms. Beverly, I don't see a valid objection to the writ of garnishment. You still have the right to challenge the underlying judgment. You can file something if you believe that you should not owe this money or that case was not properly brought before the court. You would have to go back and file some type of motion, perhaps a motion to set the default aside and show good reasons as to why you didn't respond in a timely fashion. The law allows you to do those kind of things. But at this point, the judgment is validly entered, and the plaintiff has presented a valid garnishment. So they have the right to collect under the garnishment. Now, what that means is that if you have money coming back from the state, that money will be intercepted to pay this judgment. If there is something left over, it will be sent to you. The second thing that it means is that if you file documents establishing that this case should be set aside or judgment set aside, the plaintiff will be required to refund to you as obtained. So if you're successful at getting this case, the judgment set aside, the money that will be received by the plaintiff, they would have to return that to you. But at this point, we don't have a valid objection, and so I'm denying the objections, and I'll release the funds to the plaintiff. I do wish you well, ma'am. I hope that you'll receive a copy of my order. You also, I hope that you understand the procedures. If you wish to do anything further on this, you do have certain rights that you can exercise. All right, all the best to you. Thank you, counsel. Good day to the two of you.
Well, thank you, Your Honor.
Thank you.
The court now calls case number 21-48691. This is Auto Advance America versus, well, I call this bill. That's the one that I didn't see.
Which one?
With the, that's 8691.
Oh, yeah.
Judge, can you say that case again, please?
That case is, the case number is 21-48691. That's Auto Advance versus Whitney Kayla Thomas. Mr. Nathanson, P number 41633, appeared regarding this particular map, and the defendant did not appear, and so the objections were denied. I didn't have the case in front of me at that time, and I've since found it. So now we're going to fill out the proper paperwork. The court now calls case number 21-240-431. This is Monty Howard versus Michigan Auto Recovery. The matter is before the court, set on a motion for summary disposition. Your appearance for the plaintiff in this regard. Plaintiff regarding okay, do I have Mr. Monty Howard on the Zoom? Say something if you're here.
Yes, sir, I'm here.
All right, morning to you, Mr. Howard. You're not represented by counsel, is that true, sir?
No, sir. I reached out to Lakeshore Legal Services because I don't have money to obtain an attorney, and they will not be able to give me an appointment until in April. I think it's April the 4th, when I can bring in all pertinent information to the case and I can talk to an attorney.
You have an appointment with them April the 4th?
Yes, I believe it's April the 4th. Let me see.
Counsel, your appearance for defendant as Mr. Howard is looking for some items for defendant.
Yes, good morning, Your Honor. Thomas Stidham, P 56504, on behalf of the defendant, Michigan Auto Recovery Service Incorporated. And Mr. Gregory Arrigo, the president of the company, is on the line as well.
All right, thank you. Good morning to the two of you as well. All right. So what were you saying, Mr. Howard?
Yes, it will be April the 5th when I have an appointment.
All right. Did you receive a copy of the motion for summary disposition that the defendant filed in this case?
Yes, sir. And the information that was in that document was not true. I don't know who they were talking about because I was never stopped by the Detroit police. So I need to take all that in so the attorney can look over this.
All right, very well. So counsel, defendant is asked, strike that, plaintiff is asking for and adjournment, he has an appointment to speak with a lawyer regarding this matter. Your thoughts or anything in that regard, sir?
Well, Your Honor, this is a time and date set for the motion for the hearing on the motion for summary disposition, but obviously if the plaintiff is obtaining counsel, I would leave it to the court's discretion.
Yeah, if you've got someone that you're going to talk to, that could be beneficial to making sure that your issues get heard as well as in court. So I'm going to go ahead and give you that opportunity to get someone involved in this matter. I'll adjourn the hearing to give you that opportunity, sir. So I'm going to set it over. In, April. April 25th. 425.
Sorry, could we do that April 26th because the 25th is my birthday?
All right. I think we have the 26th. So, okay, we have the 26th. So I'll go ahead and set it for the 26th at 9:45 a.m. That's April 26th, 9:45 a.m. So as soon as you speak with a lawyer, well, they should know to do that, but have them reach out to Mr. Stidham, the lawyer on the other side, so that they can get their answer in to the motion, and so that this matter be ready to go forward on the 26th.
Thank you.
9:26 motion hearing.
And Your Honor, may I ask, does the defendant need to re-notice or issue another hearing on a notice of hearing? Or
No, sir.
okay,
You'll get that from the court. The court's going to send out a notice of hearing for April 26, 2022, 9:45 a.m. And that notice will say that it is set for motion.
very well. Thank you, Your Honor.
All the best.
Have a good day.